Hello everyone, I am Anshula Gupta from Laudable. Today we will be studying the meaning and definition of the terms judgment and order as defined under Civil Procedure Code 1908. Do listen this video till the end and don't forget to like, share and subscribe the video. So, judgment. This term is defined under section 2 clause 9 of Civil Procedure Code 1908. So as the term judgment suggests, judge plus ment. So any statement given by a judge on the grounds of decree or order is a judgment. Now what are the essentials of judgment? It has got 4 essentials, but these essentials are only for those courts which are not court of small causes. So point number 1, it is a concise statement of the case, like brief facts of the case. Points for determination, like points on the basis of which the judgment is given. The decision on the basis of the points and the reasons for such decision. Now essentials of judgment of court of small causes. Point number 1, the points for determination and the decisions thereon. Now the leading case on judgment. Supreme Court in Balraj Taneja versus Sunil Madan held that a judge cannot merely say a suit decreed or suit dismissed. The whole process of reasoning has to be explained for deciding the case in one way or the other. So any judge cannot straight away say that the following party has won the case or following party has lost the case. They have to explain the particular reasoning on the basis of facts, so that they can reach on the particular decision and the party can also understand that decision. Also, an order passed by a central administrative tribunal cannot be said to a judge to be a judgment as per the provisions of Civil Procedure Code. Now, when does the judgment has the force of law? Only a judgment which is signed and dated by the judge at the time of pronouncement in the open court is a judgment as per Order 20 Rule 3. Do remember this, Order 20 Rule 3 of Civil Procedure Code. A judgment should be signed and dated by the judge at the time of pronouncement in the open court. Now next important question, can a judgment be altered? A judgment cannot be altered in normal parlance, but as once it is signed and dated, it is very clear that it cannot be altered or amended. But it has got 2 exceptions. Point number 1, as per section 152, a judgment can be altered to correct clerical or arithmetical mistakes or errors due to accidental slips or omissions. And point number 2, for review as per section 114 of Civil Procedure Code. Now, copy of the judgment. The provisions related to copy of the judgment are given under Order 20 Rule 6A of Civil Procedure Code. So, as per this Order 20 Rule 6A, the copies of the judgment shall be made available to the parties immediately after the pronouncement of the judgment, so that they may file execution or they may prefer an appeal, whatever they want, by payment of prescribed fee by whatever rules prescribed by any High Court. Now, the meaning of the term order. Order, we often hear when we file cases that order or decree has come. So, this term order is defined under section 2 clause 14 of Civil Procedure Code 1908. Now, what is an order? So, anything which is not decree is an order. Since Civil Procedure Code does not give the proper definition of the term order, so for understanding the term we need to understand the meaning of the term decree. Order as per Civil Procedure Code is any formal expression by a civil court which is not a decree is an order. So all those things which are not included within the provisions of the term decree are order. Now, in my next video, I will be explaining the meaning and essentials of the term decree. So stay tuned and stay safe. And don't forget to like, share and subscribe this video. And the PDF of this video is given in the description box. The link to the PDF is given in the description box. I hope through this video your concepts for order and judgment must be cleared. Please do post your reviews and doubts in the comments below. Thank you.